was decided on just to, Your Honor, I had indicated to him that we will be coming to court tomorrow, which is Friday, for purposes of plea taking, and that was the agreement. Your Honor, then in the morning the matter came up. Mr. Asa was by chance in court, I think he was served yesterday, and when he called me I told him that I had told my client to be standing by.
The documents were received, yes. I think in absence, but by
yes.
What brings us now?
Yes, Your Honor, just one application. Your Honor, warrants were issued. We apologize. We were not a first accused person. We applied that the same be lifted so that the plea can be taken. My client is in a stage to take plea. He's in court, and at least he's some charges so that we can move on with the process. We apologize for any inconvenience that has been caused to the court. In the media, read enough pictures.
I had indicated in the morning the predicament we had in him appearing today. However, I do not believe that his absence will prejudice the proceedings of taking plea. We can go ahead and take plea in respect to accused one.
So, my court assistant, go ahead and...
Count number 1. The charge is conspiracy to defraud, contrary to section 317 of the Penal Code, and particular, sir, on or before the 9th day of December 2020, within the Republic of Kenya, jointly with the others not before court, conspired to defraud Mr. Ashok Rupshisha and Iten Kumar Amritlal Raja for parcel of land, known as land reference number 64011-1, measuring approximate area of 7.39 hectares, situated along Lower Kabete Road, valued at Kenya shillings 1,350,000,000, the property of Ashok Rupshisha and Iten Kumar Amritlal Raja. Davis, Nathan Chelogoi, true or not true?
Not true.
Not true. Count number 2, the charge is possible detainer, contrary to section 91, 20 and 12 December 2023, along Lower Kabete Road within Nairobi City County in the Republic of Kenya, being in possession of land, reference number 18485, inland register, that's IR number 64011-1, of approximate area of 7.39 hectares, situated along Ashok Rupshisha and Iten Kumar Amritlal Raja without color of right, held possession of the same land in a manner likely to cause a breach of peace or reasonably apprehension of breach of peace against Ashok Rupshisha and Iten Kumar Amritlal Raja, who are entitled by the law to possession of the said land. Davis Nathan Chelogoi, true or not true?
Not true.
Count number 3, 18485, inland register, IR number 64011-1, approximate area of 7.39 hectares, situated along Lower Kabete Road, valued at Kenya shillings 1,350,000,000. Forged a certain document, namely a letter of allotment, reference number 75707, dated 31st January 1995, for land reference number 18485, land register, IR number 64011-1, purporting it to be a genuine and valid letter of allotment issued by the Commissioner of Lands. Davis Nathan Chelogoi, true or not true?
Not true.
Count number 3, 5, IR number 232908, bearing a forged signature and stamp impression of Pauline Acheng Pesa, to service number 80936, Detective Corporal Nicholas Ozuri, purporting them to be genuine and valid letter of allotment issued by the Commission of Lands and such, issued by Pauline Acheng Pesa, a land registrar with the State Department of Lands and Nathan Chelogoi, true or not true? Count number 6, obtained 21 at the State Department of Lands and Fiscal Planning within Nairobi City County in the Republic of Kenya, jointly and unlawfully with intent to defraud, procure registration of a parcel of land known as Mitch, area of 7.39 hectares, situated along Lower Kabete Road, valued at Kenya shillings 1,350,000,000, by falsely pretending that David Nathan Chelogoi is the lawful and the registered owner of the said land, reference number 18485, Inland Register IR number 64011/1. Davis Nathan Chelogoi, true or not true?
Not true.
Those are the charges.
For bond, the accused should be admitted to establish under the Criminal Procedure Code, that's Section 123, and under Article 49 of the Constitution. Bond as a constitutional right is usually granted by the court once the party establishes, number one, Your Honor, that an accused person is not a flight risk and will diligently return the court. Number two, the court then will set terms of bond as commensurate to the charges that are before court. There are 2 points. Number one, Mr. Davis Nathan Chelogoi is a senior citizen of stability, integrity and reputation, having served this country for over 35 years, in fact 40 in service. Previously served, Your Honor, as a district commissioner, in fact started as a DO way back in 1980s. Served in different countries, served as a district commissioner in Bureti and Nakuru, and deputy PC Nairobi. Before retiring in 2020, Your Honor, he was the coordinator of the wider Rift Valley province, like an RCC, from the office of the president. Served as the PA to the head of public service for many years. You know, this is a man with a track record and a man of repute, and who has sat in land boards, knows the systems. And Your Honor, just to briefly mention why these are charges that will be, this trial will go through a proper process. We will establish, Your Honor, that Mr. Chelogoi secured an allotment and a lease process in the normal manner, and they will demonstrate.
Maybe we just
Yes, I'll avoid
that
yes,
so that
yes,
we don't get
yes,
to the merits of the matter.
Your Honor, let me move to the point that he bears no guilt in terms of what he set out, but Your Honor, from the time the charges, the accused person was called to court, he has not been in good health. I have supplied, Your Honor, to show that the accused person was on a flight risk. So there's a record, his health record from Nairobi Hospital, where he has been attended to by Dr. Mwela Namasaka severally. And Your Honor, the first time this matter was called to court, the accused person had traveled to Uganda on a visit without knowledge at the time that the case was covered. That you grant lenient bond terms to the accused person. You would have paid for personal bond because they're a senior citizen and has rendered services to this country. But Your Honor, because you have another charge against the first accused person who has been admitted to bail, the second accused person, who has been admitted to bail on terms set by the court, we appreciate that the court's hands may be tied to grant the same terms because of the provisions of Article 27 of the Constitution. We will have no problem, Your Honor, because we understand that the hands of the court may be tied. But we plead, Your Honor, that this is an individual will respect and attend court. He's not a small boy, he's a man who understands the process of the courts. He's served in administration and will attend court at his own instance. Your Honor, we will be ready to abide by the hearing terms that have been set by the court.
And every time there has been an excuse and a reason given as to why the accused person couldn't take plea. Your Honor, even today, when the order was very clear that plea taking shall be on the 21st.
I think 22nd.
The order said 21st of March 2024. It was very clear, Your Honor. There was no show of good faith. Your Honor, the Constitution is very clear. Article 49, subsection 1H. Provides that yes, the accused person has the right to being granted cash bail or bond. However, if there are compelling reasons for the same not to be granted, then it should not be granted. And Your Honor, I also refer to the bail and bond policy guidelines. Your Honor, and in the same guidelines, court should also take judicial notice of the conduct by the accused person in granting bail or bond, and also, Your Honor, the seriousness of the offences before court. Your Honor, should this honourable court be inclined to grant bail or bond, we pray that this honourable court only grants strict bond terms without the option of cash bail. And we also pray that the accused person deposits his passport with court.
Maybe we could then be admitted to hospital.
March 2024 in the morning.
Yes, sir.
I really don't want to get into where he should be. Just a minute, Michelle, just a minute. I don't want to start getting into the nitty-gritties of all these things. I will give a ruling on the 25th of March 2024.
Yes, Your Honor, because
Just a minute. And I know now the next question will be, where will you be put? Earlier on, there's a warrant of arrest. I've not mentioned anything about that. There was a warrant of arrest. I've not mentioned. I'll say I'll give for bond and bail 25th of March. Should I also now execute where I should be taken?
no, Your Honor, normally when
If I say anything more than that, then I'll be
At, it's also not going. It's not also very easy for me as a court. But I will definitely give a ruling on the 25th of March about the bond and bail. As to where he is going to be taken, I will not want to delve in that. And why I don't want to mention that, because this case already is building a history. So I 2024.
Your Honor, what time?
At 9.
At 9.
With your kind permission,
Yes.
perhaps I would seek the indulgence of 9th of April.
Of April.
his
So
attendance.
we are done with him. He has a hearing date. You have the documents.
Thank you very much.
Yes, for this one, I give a ruling on the 25th of March and 2024 and cancel a senior council agenda, just as you had directed and also made your submissions, that I also, in favor of your client,
Yes, ma'am.
that I should also see that those are, that's accused one.
Yes, that
Accused
is
one.
accused one.
Yours is
Is
accused.
the accused one? Is accused two?
Accused two.
Yes.
Yeah, and what I gave as the bond terms for accused two
Yes.
should also be considered.
Yes,
Yes, and that is why, because you're in this matter, I don't want to delve in that, but I will equally consider that.
Yes, ma'am.
And even when he took plea, I retreated and wrote a ruling. So my ruling will be pronounced on 25th of March, 2024.
Your Honor, you have not,
You should that the accused person should be taken. The court directs itself to what is before the court, which is an application for bond and bail. It is not an application where the accused, now he's an accused,
yes,
and because he's now before the court and he has taken plea.
And I
But
said-
the court does not take, does not further direct where an accused person who has taken bail, you know, counsel, you know what happens. Let me not get into that because that is not an application before the court.
we know, okay, we normally situation of concern.
I was avoiding that
Yes.
because we've just come from Nairobi Hospital and you
Yes.
know what happened.
Yes.
I have seen the application that we had and I can
Yes.
see now Nairobi Hospital was involved.
Yes.
It would only be fair enough that application on something which is not before the court. Yeah.
Your Honor, I think to be clear, when a party takes plea,